Yes, Mr. Quintiferli, are we moving on to ground 5, are we?
Yes, I had been asked a few questions. And
just a few.
Dealing with the ones I can answer quickly.
Thank you.
So the PC in York case was one where the lady under concern had significant learning difficulties, and that there wasn't a dispute about that. So it fits precisely. I submitted to the JB type case where question 1 didn't have to be asked. The other point I was asked to reflect upon was on the need for what sort of evidence a judge would need, just to be clear on what the submission is. Submission is that the court has to decide what sort of evidence is appropriate, but some sort of evidence would be necessary. Some sort of medical evidence would be necessary. Who provides it would be a factual matter, which the court would make a determination on. But whoever provides that, the diagnosis that there is an impairment, will inevitably have to be someone with some sort of medical training. And if we see the list of conditions which the Mental Capacity Code anticipates fall under impairment, they're all ones with the exception of possibly of alcohol.
So we have to delete social workers from now on, do we?
Not as far as capacity is concerned, but as far as impairment is concerned. And this was the distinction I was trying to make, is that most of the times that the court is called upon to decide this issue, the existence of the impairment just simply isn't an issue. It's not under dispute. So at that point, it's appropriate for a social worker it may be appropriate for a social worker to express an opinion on capacity, but the capacity is not the impairment issue. That was the distinction. But the point being that in any case, there has to be some sort of evidence before the court of the impairment. And the difficulty in this case is that, in my submission, there wasn't any proper evidence, because Dr. Tunnicliffe, who did suggest that there was a delusion, it doesn't appear that he had, in fact, himself conducted any sort of assessment that in any case was compliant with the Mental Capacity Act. And so this is a problem. It would be a problem for a judge who was trying to then come to a capacity determination when premise to that determination, what we say question 1, whether or not there was an impairment hadn't been established. So that's my answer to
Thank you.
that point. As far as revisions to the code go, I'm unable to provide any assistance on that, because I don't know where we're at. It may be
Mr. Rakim will be able to help us.
Yes.
I will, my lord. Yes.
I was also asked, so on the issue, the question that was asked just before we adjourned, related to the fact that capacity was something that under General Medical Council guidelines was open to all clinicians. But again, the important distinction I repeat for the purpose of my submission is that distinction between impairment and capacity. Once one's established that an impairment exists, then it can be open to all sorts of professionals to make a capacity determination. But where there's a doubt as to whether there is an impairment at all, then that's where the professional medical input is needed, and it may need to be a specialist input where there's absolutely no evidence of any impairment at all. I was also asked if I could refer to, point out the various parts of the judgment in which references were made to Dr. C's evidence and to, sorry, Dr. Wallace's evidence and to Dr. Tunnicliffe's evidence. And there's not much reference to Dr. Tunnicliffe's evidence. I could only find 2 paragraphs, which were at 94, paragraph 100, which dealt with that. With regards to Dr. C's evidence, there's several points in the judgment which reference is made, starting at paragraph 92. Dr. C accepts that she fails a functional test, and at 93, the judge agrees with the conclusions as to that. And then 94, at the end of that paragraph, Dr. C confirmed in his evidence that ST was unable to weigh up any decision about palliative care because she failed the functional test. At 95, reference is made to the preponderance of the clinical and expert evidence from Dr. A, Dr. B, and Dr. C, that ST's views regarding her prognosis and the prospects of treatment were both false and fixed. Then, as far as the changing of views is concerned, there's paragraph 98. Dr. C struggled to identify precisely how to label ST's condition. His evidence was that her beliefs, which he accepted to be false, did not amount to a delusion. And then the last sentence there is his concern about making the causal nexus between lack of ability to make a decision and the impairment in question was that none of the treating conditions had identified a physical problem in her brain, or that her recent respiratory arrest had affected the functioning of her brain. That much is agreed. And that, in my submission, does not accurately reflect Dr. Wallace's conclusions and findings, which we had a look at before, which are at page 180 and 181 of the bundle. His conclusion is that there wasn't an impairment. It wasn't that there wasn't an impairment because he couldn't find a causal nexus, or there wasn't an impairment because there wasn't a physical problem. He notes that there wasn't a physical disturbance, but that's not the reason that he concluded that there wasn't an impairment. His reasons are given, and he goes through them clearly. Why he believed that the beliefs were rational, why there wasn't paranoia, and why her false beliefs, as he saw them, were due to her accepting the views of her family. He considered whether the impairment could have been caused for reasons which went beyond any physical problems. And so paragraph 98, where the judge is looking at Dr. Wallace's evidence, in my submission misrepresents, in fact, the conclusions he came for, the reasons he came for those conclusions. Then we have further references made at paragraphs 100, 101, 102, 103, and 106. But the important one, my submission's paragraph 98, which does show, which is where the judge is having to look at how to answer this question, the causal question, and my submission misrepresents Dr. Wallace's position, and in a very material way. And what we then essentially see, and I don't wish to repeat my submissions, but the explanation she comes up with is essentially the very explanation that Dr. Wallace had adopted in his first report, but which he then rejected.
Could you just highlight, without going back to it in any detail, the paragraphs in the first report which you say were reflected in paragraph 103 of the judgment?
In
That's 11.1 and 11.2.
Is it page 147, 13, 11?
Thank you.
Yes, thank you.
so
We have your submissions. I think we've probably dealt with Moneywood's theories.
So we're on to the final two grounds, which I propose to take reasonably quickly. Ground 4 relates to the untested evidence on physical health, and I've dealt with this.
You have. You've threaded it through your oral submissions.
The issue relates back essentially to the scope of the hearing and the dispute as to whether best interests should be heard as part of the hearing or subsequent to the hearing. And the decision was made, as we saw, by Mr. Justice Peel, that the best interest would follow the capacity decision. But the upshot of that is that the great bulk of medical evidence that has been put in was not, in the very few days between the hearing before Mr. Justice Peel and the hearing which was being organised for capacity, were not upon the expectation of the parents or of Sedicia, ones which were going to be matters which were under which were needed to be resolved, which were under dispute in the hearing, and there was no provision had been made in the order of Mr. Justice Peel. We did make provision for the possibility of applying for an additional expert on capacity by Sedicia, but no provision, no directions were made for any experts who were to deal with any of the factual matters which would have been under dispute had the matter gone forward to a best interest hearing. And I dealt with a few of those factual points that were under dispute. And what the approach that the judge took can be found at paragraph 83 of her judgment on page 71 of the core bundle. where she says, in this context, and in terms of a patient-centred approach, it is important in my judgment for the court to consider the extent to which the information provided to a person is capable of being established objectively as a fact or a truth. The less certain the fact or truth, the more careful the court must be when determining whether the presumption of capacity is rebutted. And that's reasoning, that approach is taken from the MN case. Now, if that is an accurate summary of the law, the problem is he then proceeded to make findings on nearly all the factual issues which were disputed in relation to the best interests.
Sorry, can I just be clear?
Yes.
I'm not sure what is, when you're saying is disputed, as I understand it wasn't disputed that she was going to die and die quite soon. The question was whether or not, what treatment she should receive, and whether or not efforts should be made for her to go to take part in some experimental treatment, mitochondrial treatment for a different type of mitochondrial disease.
Well, that was, in fact, one of the central matters which was in dispute.
So it wasn't, you're saying it was in dispute that she had a terminal illness?
It wasn't in dispute that she had a life-limiting condition. It was in dispute that she was at the terminal phase of her life. This is recorded in the evidence as well, and this is why the Dr. Tunnicliffe was saying she's not accepting that she's going to die, because she didn't believe that her condition...
No, I understand that what her belief was.
Oh,
But was there a wholesale challenge? I mean, she could have her belief, which we know she had, but it could be that the overwhelming clinical evidence, which couldn't actually be disputed, was that she was at the last stages of her illness. But the question was the fact that she felt unable to accept that or believe that, whether that meant she was incapacitous.
Well,
so I'm getting a bit confused, because I had not appreciated until you made these submissions that it was saying, and she was right, she wasn't going to die, because there was going to be a wholesale challenge to the medical evidence to that effect.
So, paragraph 85 of the judgment records the two different opinions. And the judge says that she's quite satisfied on the objective basis from the body of medical evidence that it was the mitochondrial disease which was causing the progressive failure of her respiratory muscles. And it wasn't the residual after effects of long COVID, as ST believes it to be. But the point is, that's what ST did believe it to be. And if there had been a best interest hearing, this would have been a central issue which needed to be determined. Sadiksha was ill. But she was ill. She had been suffering and overcoming various very big challenges in the hospital, including the perforation of her stomach and the problems which followed from that. She was certainly recovering from COVID, whether or not.
Well, that was a year before. Isn't it? I got that wrong.
My lady, it's not my position to give evidence. My understanding is that she continued to test positive for many months going forward. But in any case, the effects of COVID on debilitated...
Anyway, so you say there is a wholesale challenge to all the medical evidence.
That issue was certainly disputed by the family, and certainly disputed by Sadiksha. Their position was that if she was allowed to recover and from the effects of COVID and from the effects of her perforated stomach and the other problems that she'd had, that she would have slowly been able to regain strength. And if she had had the nucleoside treatment, which Sadiksha herself recognized, this wasn't a certainty. She said it may work, it may not work. But that may have given her the ability to move on in life. And there was talk about her getting a kidney transplant in order to overcome the problems that she'd been having from her kidney failure. So she was fighting to live, not just for a few months.
That there is absolutely no doubt. Please don't. I hate to have family to think that I'm misinterpreting that. I'm absolutely clear that she really, really wanted to live, and she was prepared to try anything. But that's very different, and that was her belief. That is different from what medical evidence was. And I was trying to tease out from you the difference between her belief and the actual medical evidence. And I now understand that you say that the actual medical evidence was going to be challenged.
It was. And one of the reasons it was going to be challenged was that the finding that the judge made, that she's quite satisfied that it's the mitochondrial disease which was causing this, would have necessitated evidence from the mitochondrial expert. And the only mitochondrial expert whose evidence was before the court was Professor McFarland, who provided a short letter. The treating clinicians themselves didn't have expertise in the mitochondrial disorders, so they were relying, understandably, on Professor McFarland's views.
I don't think we need to go into all of this, because then you immediately lead into the fact that Dr. Tunnicliffe was saying, yes, but I'm a respiratory expert, and her respiratory state was that she was towards the end of her life. That actually, does it matter whether it was COVID or mitochondrial disease? And we don't want to get into that. If you tell me that the whole of the medical evidence was going to be in dispute, contrary to my understanding, then of course I accept that and I'll proceed on that basis.
The principal points in dispute were that what was the cause of Sudiksha's current presentation? Was it a result of mitochondrial disease, or was it the after effects of COVID? Secondly, were there any concrete offers of treatment in North America, or was it totally fanciful? And the question of whether she would have been eligible or not for the North American trials, even if they did exist, because that was an issue which led the treating clinicians to consider this as rather fantastical, this notion that even if these trials did exist, she would have been eligible to take part in them. And then the other issue was whether or not the move to North America would have been very dangerous for her, because obviously, even if she was eligible for the trial, if she couldn't get there, then that wouldn't have made that option something that would have been of any benefit to her. So these were key factual issues which the judge considered and was clear in her conclusions about. But unfortunately, they weren't issues upon which the family had had any opportunity at the capacity hearing to present any evidence on or to challenge. This is Justice Roberts realizes it at paragraph 91 that she says, after having gone through these various findings, she says, I say this not in the context of anticipating in any way a best interest decision about this potential treatment, but because it is information relevant to the decision which ST wishes to make in terms of a future treatment without interference from the doctors or the court. But the problem is that findings were made, and it may be that that it was necessary in the context of establishing whether there was a mental impairment that findings of fact needed to be made if one was looking at whether there was a rational basis for the belief or whether there was any delusion. But the problem is that this isn't what the original directions of Mr. Justice Peel anticipated, that this hearing was going to turn into a medical fact-finding hearing covering the same ground as a best interest hearing would have had. And that's the root of the of essentially the root of the unfairness, which is what this ground is about. And it centres very much on the opinion evidence of Professor McFarlane, which can be found at pages 188 to 189 of the core bundle, tab 6.7.
This is Dr. E, isn't it? Dr. E in the anonymised judgment?
Yes, I believe so.
So the judge's summary of that evidence is 23 and 24. Do we need to go to the report, or can we stick to the summary of what
we can stick to that
for the purpose of your submission? It's page 54, paragraph 23 and 24 of the judgment.
Yes. But what the points the family makes in relation to that is that there'd been no opportunity or permission to adduce evidence on the availability and efficacy of nucleoside treatment abroad. There'd been no opportunity to instruct their own expert on mitochondrial disease to counter the evidence of Professor McFarlane. And it wasn't possible to test Professor McFarlane's evidence in cross-examination because his evidence was just that short letter. And Professor McFarlane hadn't visited Sudiksha since she had been hospitalized. So this letter wasn't written following any sort of personal visit. It was a letter written, no doubt, on his considerable professional understanding of the progression of these diseases. But Sudiksha's condition was an incredibly rare condition. Very few people have it. And Professor McFarlane, his noted expertise, he's a pediatric expert on these mitochondrial conditions. Sudiksha was someone who'd overcome the pediatric stage and was now an adult. And there was the possibility of the various treatments which might or might not have materialized, or which he might have been eligible for in North America.
The report, his letter's dated the 11th of April, so that's 3.5 months before the hearing, 4 months before the hearing. Did everybody have that letter on at that time, or was it only produced late in the day?
I've no reason to doubt that people didn't have that.
Would it not have been open then to somebody who, given the importance of his evidence as the basis for all of these matters on your case, was it open to somebody to apply for another witness?
Well, it may have been, but it would have been very difficult for Sudiksha. Her views, which she made very, very clear when the official solicitor representative visited her of what she wanted to be raised in court, were not views which were then given any account of. For example, she was adamant she wanted reporting restrictions removed because she wanted to fundraise for her treatment, which would have been expensive. But the official solicitor then said, "Well, I'm not prepared. I don't believe they should be raised." So, and the official solicitor, subsequent to that meeting, it appears didn't have any contact with Sudiksha anymore after that meeting. So Sudiksha was in a position where difficult for her to challenge any of the opinion when the person who'd been appointed to be her legal representative wasn't able to or hadn't communicated with or made any contact with her or discussed the implications of this evidence. That was part of the concern. The parents were labouring under a different concern, and it's one. Again, I'm reluctant to, not wishing to give evidence, but they were under very serious financial constraints. They'd got heavily into debt to pay their legal fees. It wasn't an easy situation for them, and they were doing what they could in the face of a difficult situation. And at the same time, of course, there was the care of Sudiksha herself, which needed to be followed. So it was certainly anticipated that there would have been a challenge in due course if the matter had gone before the court. But the position up until then was that Sudiksha wasn't a incapacitous person, and that's the battlefield they were on up until the hearing before Mrs. Justice Roberts.
When considering whether the judge was entitled to come to the decision she did, or make the finding she did at paragraph 85 of her judgment on page 72, which is the basis of your submission, the evidence on this before her was all one way, and there'd been an opportunity for those representing ST to seek a further opinion, but that had not been done. Is that right?
So the people representing ST were the official solicitors.
Yes.
They hadn't, their position before, and it's in their, may not be in, if it's not in the position statement before Roberts, it was in the one before, but their position was they hadn't been able to commission any additional medical evidence yet. But they were also, their position previously had been, we've got to resolve the capacity issue before. And this was the issue that they felt was the pressing issue before any medical evidence was commissioned. And so that's really that's the position we found ourselves in. Now, it may have been, if Mr. Justice Peel had said, we need to consider the medical evidence in order to come to a determination on the capacity issue, then no doubt directions would have been given to the family and to Sedictia's alternative representative, as was made with regards to the expert psychiatrist and the capacity evidence. But directions would have been made providing for other evidence to be submitted on the medical issues. But there weren't those directions, because that wasn't what the hearing was anticipated to be. And that's...
Thank you for interrupting you, but I just want to... These are quite... This is obviously a major plank of your argument, as you see it, that the judge in some way proceeded unfairly on the basis of evidence which was put before her, which was intended for a purpose other than the capacity determination. That's your argument, isn't it?
Yes.
The evidence was put before the court on the 11th of April, and before the other parties, serving other parties, all parties on the 11th of April, or after the 11th of April, soon after. That was the basis upon which the court's jurisdiction was being invoked. Why do you say it's unfair for the judge to proceed on that basis, given there was no challenge to it or no attempt to obtain a further report over 4 months, just under 4 months?
So the court's jurisdiction, and it's why I wanted at the beginning to have a look at the procedural background to how this application came about. But the court's jurisdiction was not originally one which was a best interest jurisdiction. The court had been seized of the matter under a challenge to the lasting power of attorney on the basis that Sedictia didn't have capacity. There wasn't cooperation with having a capacity assessment, and so at that point, at the time the matter first came before Mrs. Justice Roberts, that was the matter which was felt necessary to address. And that's, in whatever context the evidence from Professor McFarlane had been put before the court, and it may have been simply to show that it was a matter of urgency and the court needed to decide this issue quickly. It wasn't because it was anticipating any sort, in my submission, any sort of dispute regarding her prognosis. It was at that point in time, it was a question of capacity which the court had been called upon to resolve. Later, an application was made by the trust in June, I believe, for a best interest hearing, and that's when all the other medical evidence was put in. But the regardless of whether that evidence was available to Sediction, should have been challenged by the official solicitor at an earlier stage. The fact is that it didn't form part of the subject matter in my submission of which had been agreed, which had been anticipated by Mr. Justice Peel's order setting the capacity hearing. This wasn't what was going to be considered. What was going to be considered was the psychiatric evidence, and that's why the importance was on obtaining reports, new reports from Dr. Minus-Wallace, Dr. Bagshi, giving Sedictia's alternative representatives the possibility to make an application for another psychiatric expert if they felt it was necessary, which they did. There was no suggestion that this was going to look at any of these factual questions which remained under dispute. And the simple point is then I make with reference to the Re-G&B case, which we looked at earlier. And this time I look at it, paragraph 16 on page 619 of the authorities bundle. And what the Court of Appeal there said this, and this was in the context of a judge in a hearing deciding to devote attentions to resolve matters which weren't originally going to be subject to the hearing. And the Court of Appeal says, if the judge is, as it were, to go off piece and to make findings of fact which are not sought by the local authority or not contained in its schedule, then he or she must be astute to ensure, A, that any additional or different findings made are securely founded in the evidence, and B, that the fairness of the fact-finding process is not compromised. And the point we make is it was certainly open to Mrs. Justice Roberts to say, look, I'm not going to be able to determine capacity unless we look at whether these factual matters are true or not. But if that was a decision which was made, then it was important that the fairness of the fact-finding process was not compromised. Then that means that Sediction or her parents should have had the opportunity to adduce their own evidence, and not least to cross-examine Professor McFarlane if his evidence was going to be central to the determination which was made. And I don't need to take the court to it, but I put in the authorities bundle the case of Al-Rawi and the security services, paragraph 13 of the Supreme Court's judgment, where the right to cross-examine a witness who's producing evidence against his position is considered an aspect of the principle of natural justice, which the courts have to uphold. Then the final point of this ground if I could just, before I move to the final point, it would be useful to look at Mr. Justice Peel's order, which can be found at tab 16 of the supplemental bundle, at pages 85 to 87.
Yes, I've already got that turned up.
And his order paragraph 1, there was the hybrid hearing to determine capacity to litigate, capacity to consent to medical treatment, and importantly at C, directions for the best interest issues. And then if there's time, the second and third respondent's application to vary or discharge the transparency order, and there being no need for any further evidence filed as to that. But that's what Mr. Justice Peel anticipated, that if there was if Sir Diksha was found not to have capacity, and so that a best interest hearing would have proceeded, then at that point, directions would have been made in order to provide for the evidence in that. The final point on this ground, it relates to the re-MM principle.
So are we moving on to ground 6?
No, just the final point on this ground, which I'm nearly finished with. But it's a point I made before, and so I don't need to go into in any detail now. But it's this question about what it means to make a finding of truth. And we say that there is a difference between matters which are amenable to a finding of certainty and ones regarding the future which just simply are not. And this did go to the heart of this issue, because the determination and or the concern in this case was that Sir Diksha wasn't accepting what doctors were telling her about her future. And for whatever reason, she didn't believe that things were as serious as they'd been painting for.
Or as in fact as they were. Or in fact as they actually were.
Well, my lady, the fact is, and this is something that came out in Dr. Tunnicliffe's evidence, is that the doctors had for some time been saying that she's only got days, or at most a few weeks to live. We need to have this decision made very quickly. We haven't got time to wait for the Office for the Public Guardian to ratify whether the LPA is valid or not. So the imminence of death is something that the doctors had been convinced of for many months back, and this was perhaps one of the reasons why Mrs. Justice Roberts picks up on this. I haven't got the paragraph under my thumb, but the fact that some of these predictions had been wrong was also a reason why someone could rationally believe that or could distrust the clinicians when they continued to say, no, now it really is the end. Well, you've been saying that for months now, and I'm still soldiering on. But in any case, the question is that at the time, what was the situation and what did procedural fairness demand? And parents' submission is that they entered into this capacity hearing prepared to challenge, if necessary, the evidence on impairment and capacity from the psychiatric experts. Instead, what the judge then took into account was all sorts of other evidence, which wasn't part of the scope of the original hearing. That, my lady, my lords, is ground 4. So I could turn very quickly to the last ground, which is an important ground, and I'm not going to say very much about it because my learned friends, Ms. Gollop and Mr. Upkeen, are going to be dealing with this ground, so as not to duplicate matters. I'm going to leave the bulk of the submissions to them, because our positions on this ground are essentially aligned. That we don't accept that in order to be able to understand for the purposes of Section 3.1 of the Mental Capacity Act, there is a need to believe the information. And in particular, I commend to the court my learned friend Ms. Gollop's detailed and precise dissection of the Pre-Mental Capacity Act line of authorities and why that analysis was problematic even in a Pre-Mental Capacity Act world, and certainly shouldn't be adopted now. But in short, the submission is that the Mental Capacity Act does not contain an express belief requirement, and that none should be imported into the Act. So the only question is, in the absence of an express belief requirement, is such a requirement logically necessary component of understanding? And the Trust say it is, and their position is summarised in paragraph 3A of their skeleton, where they say, where there is objectively verifiable medical consensus as to the consequences of having or not having treatment, a person must believe or accept as true that information in order to understand it. And we say that this argument is premised on two closely related but false propositions. The first is the premise that one cannot understand something without believing it. And we say that this, in fact, doesn't require a great deal of analysis to be seen to be false. One can understand, for example, what a religion teaches without having to believe that religion. But similarly, in this case, one can understand what doctors are telling me about what the future holds for me. Understand that they're saying I'm going to die, that I'm going to be in pain. But I don't have to accept or believe that they're right in their prognosis. It simply doesn't affect understanding. When one looks at section 3.1, one sees that the requirement for capacity is that one understands information relevant to the decision. And then section 3.4 imports that information includes information about the reasonably foreseeable consequences of making or not making a decision. But there simply isn't a requirement to believe the reasonably foreseeable consequences. It's there. One has to understand. So Diksha, in my submissions, did understand what the doctors were saying. And in her conversations, which were reported by Dr. Bagchi, but also a meeting with the official solicitor's representative, and also Dr. Minus Wallace, she did understand that she would be in pain if she refused morphine. But she had her reasons for not wanting that. And in particular, she understood what the palliative care pathway entailed, and she didn't want that. She wanted to keep on fighting.
Mr. Quintavalle, can I ask you, and forgive me if you were about to go on to this anyway, but is there potentially a distinction in law between understanding on the one hand and using and weighing information on the other hand? Because I have in mind, for example, the provision you just showed us, which talks about reasonably foreseeable consequences. As soon as you use a word like reasonable, that imports, on the face of it, some objective qualification to what is foreseeable. Now, if somebody simply doesn't believe what the doctors are telling them are the foreseeable consequences of what will happen, then is that person able to do the using and weighing? Because they don't get to base one, do they?
Well, base one, we say, is there an impairment? It's not
Sorry, by base one, what I mean is they don't believe the information. I can understand, I do understand the force of your submission, that you can believe something, sorry, you don't have to believe something and you can still understand it. I understand that point. That's why I'm asking you not about understanding, but about weighing and using. Can you use and weigh information in the scales if you give it no weight whatsoever because you just don't accept that it has any weight?
Well, there are two reasons why you may decide not to give weight to information which is being given. One is that you don't believe it.
Yes.
But another reason is that information doesn't fit in with your particular values. And so the example here relates to the issue of pain. So Diksha was told, look, we need to give you morphine to treat your pain. And she said, I don't want this. I'd rather have paracetamol, because the consequence of morphine is that, yes, I may have my pain taken away, but I also lose my ability to interact with my family, and that's what's more valuable to me. And so it doesn't seem to me, upon analysis, that she didn't believe anything the doctors were saying. A lot of it she would have understood. And she would have rather believed. It's just it then didn't fit into her values. Her values were I have to die fighting. I have to die trying to live. So even if what the doctors were saying was true, that doesn't mean I hoist the white flag in front of this and say, well, that's it.
Yes, thank you.
The value she gave to her, the value the doctors gave, the doctor's position essentially would seem to be this, that it's better for you to have a dignified death without pain, and we can provide that. Sadiksha's response was, what you're offering me may be a comfortable death, but I rather have an uncomfortable life. And that's how she weighed matters. The question then was for the court was whether the fact that she didn't believe the doctors, and this is the question, one question, very important. Does this indicate that there's an impairment? Leaving aside whether functionally she isn't able to deal with the matter, which is question 2 in the questions identified. But the question is, does this indicate that there's an impairment, a delusion, some sort of irrationality which indicates that there's a mental disorder of some sort? And in Mrs. Justice Roberts' judgment at paragraph 55, which is on page 64, and following, she looks at 3 reasons why submissions that were made, why the belief was rational, and there wasn't a response to this. But in any case, even if the belief had been irrational, that's not enough in itself to establish the existence of an impairment. And I just coming to the very end of my submissions, if I could take the court to the case, the King's College case, which is at AB Authorities Bundle 24, page 420. And I'm referring to this case because there's a very pertinent observation from Lord Donaldson, which is cited there in paragraph 1. And it says this: an adult patient who suffers from no mental incapacity has an absolute right to choose whether to consent to medical treatment, to refuse it, or to choose one rather than another of the treatments being offered. This right of choice is not limited to decisions which others might regard as sensible. It exists notwithstanding that the reasons for making the choice are rational, irrational, unknown, or even non-existent. And this, Dr. Miners-Wallace was clear that Sadiksha's reasons were rational for refusing the palliative care route. But even if they hadn't been, the question is, if there's no mental incapacity, then it's not that one infers from the irrationality of the reasons that there is mental incapacity, because a mentally capacitous person is entitled to have irrational reasons for refusing treatment.
You can believe something, you would say, even though there is no reason to believe it at all. You would say it's perfectly logical, perfectly possible in philosophy. I can believe something. I can believe the earth is flat. I can believe the earth does not go around the sun. It may be an unreasonable, it may be objectively untrue, but you say it's perfectly possible to believe that.
Yes. And Dr. Minus Wallace, he identified the principal cause for Sedictious belief was that she was sharing the views of her family members, to which she was very close. What one could imagine, and one wonders whether on the trust's arguments they were also incapacitous, and because they also believed something which wasn't objectively true. But one could imagine a situation where the parents, in order to keep hopes up in a dying patient, are telling that patient things which aren't true. Don't worry, you're going to get better. We've got an offer.
No, it's not suggested it went that far. It was jolly close to that in this case, wasn't it? Because the parents wanted to protect her, and they did to the best of their ability, which was why the medical evidence overall says that there were some difficulties in getting to the stage where she could properly understand just how serious things were. That's no criticism of the parents at all. It means they were acting like parents.
I'm not suggesting that the parents were telling their daughter anything other than what they truly believe, but I'm positing a situation where perhaps the parent knows they're not telling the truth, but they just want to provide some sort of comfort to a dying child. And so the child believes what the parents have said to them and says, yeah, there's hope. I've got this. They're going to admit me to the treatment next week, or I'm getting better, the doctors tell me. Now that flies in the face of the medical evidence. That's undoubtedly false in that situation. But the fact that the child believes their parents isn't a sign of any mental disorder. And that's the point. And Dr. Minus Wallace, who found there was a problem on the functional side, saying, look, Sedictious belief is totally understandable. There simply wasn't a mental impairment. And that's, again, why we say it's very important, notwithstanding that we say there's no contradiction between the approach that we're contending for and JB, but why it's very important that the starting point, before the court even assumes any jurisdiction to examine these matters, is that you have to establish whether there's an impairment or not. And then you get to those other questions. Not least because, and this is a point that's been raised by my learned friends, the trust and also the official solicitor, that in those circumstances, a different jurisdiction of the court can be invoked if necessary, which is the one we're not going to talk about, which is the vulnerable adults one. But it is important that one's clear on the outset. Otherwise, one embarks down a road which is ultimately a dead end, but a very exhausting, time-consuming, and expensive dead end.
There's another point, isn't there, about this, which is how do you really know what someone is believing, as opposed to hoping? I mean, what goes to the minds of ST and people like ST and her parents in the terrible situation that they're in, other cases that you've been in, we've heard, it's difficult to evaluate what is a belief, what's a hope. It's evaluated in every sense, judge.
I've no insights into Sedictious mind, but one could imagine a situation where a patient, maybe deep down, does suspect that things are pretty grim, but just doesn't want to admit that to the doctors because she wants to encourage the doctors to keep on fighting too. We just don't know. We don't know. But what I submit we do know on the evidence was that there simply wasn't a mental impairment. My lady, my lords, those conclude my sections.
Thank you very much indeed. Yes, Mr. Rumpke.
Thank you very much. Excuse me 1 minute while I just go to a bit of
Please do.
rearranging.
Do the same.
So much. Thank you. So, my lady, my lords, I appear with my learned friend, Mr. Allen. You may also be interested to know that Professor Martin, he wrote an open letter, which we referred to in our submissions. He's at the back of the court. We're very grateful indeed for the opportunity to address this court orally. We did actually only ask for written submissions.
I know you did, but I thought we needed to hear you.
Well, I'm extremely grateful. We're going to focus in, especially in light of what the indication of the court this morning, we're not going to talk about inherent jurisdiction. We won't talk about litigation capacity. So we're going to focus in on belief and diagnostic elements. We're not going to address the factual circumstances of what really must be one of the saddest and most difficult cases actually in this very sad and difficult jurisdiction to have come before the court in recent years. And I'm acutely aware that Sadiq's parents are here, and having her struggles brought to life again must be just awful. But we're seeking to do our best to assist the court with the wider context insofar as possible. Before I get to belief, and then, as my learned friend keeps telling me, don't talk about the diagnostic element, because that's the wrong word. We should be saying impairment, and I'll explain why in a minute. Could I just touch very briefly on the status of the Code of Practice, which was an issue which arose. There is sort of chapter and verse in this, in paragraph 1.81 of the 2024 edition of the Code of Practice, which I think my Lord Justice Baker...
I've left mine in my room.
I can certainly get a copy made, but in very headline terms, there was a revised code...
Sorry, we'll just get...
Sorry.
I'm just going to ask my...
I mean, I've got a copy here, if that assists.
I'd rather have mine, it's nicely thumbed.
Yeah.
I think my clerk, maybe one of the clerks may be watching on live stream. Could you ask?
My clerk's gone, so could you ask her?
I mean, it's a very short paragraph, which I can essentially just essentially set out the headline points now. So in essence, what happened was, in the context of the move towards, as the court might be aware, the liberty protection safeguards were supposed to come in to replace the deprivation of liberty safeguards. The government consulted on a revised code, which would both update the code accompanying the main body, which, as my Lord Justice Baker points out, is really very old now, and critically actually was thought about before the Act came in, so before there was any practical experience. It was people essentially doing their best to think this is what it might be. So there was a consultation between March and June 22 on that, and for your notes, it did include a reordering of the capacity test as per JB. So in other words, the draft code which was consulted upon says, start with, can the person make the decision, so functionally, and only if they can't, you then go on to ask why not. Of course, it's only a draft code. The government, essentially, there has been total silence thereafter.
It's gone to the back of the legislative queue, is it?
Well, the Liberty Protection Safeguards, so the Mental Capacity Act Amendment Act 2019, is not being implemented in the lifetime of this Parliament. Of course, that left the main body of the Act, the code relating to that, in a complete limbo.
Two codes have been brought
together, and then unfortunately, because one bit of legislation is not being implemented, essentially there's a process of trying to unglue them. There is a governmental commitment to update the main body, the code accompanying the main body of the Mental Capacity Act. But that commitment has been made some time ago, and we are still waiting.
And there are a number of areas of the code which have been not followed, or
yes,
in the light of in a number of cases, it's recognised as out of date.
Yes, I mean, to the very slight extent relevant, I led in chambers on an unofficial update which just goes through all the paragraphs which are just wrong. You know, where the courts have come along subsequently says that's just not true. And the case referred to by my learned friend Mr. Sachdeva, the Lawson and Mottram case, Mr. Justice Hayden makes it crystal clear the code isn't the law, and to the extent that what the code says conflicts with what the law is, as in down in the statute, as interpreted by the courts, the code bows to the law. So I wasn't proposing to address you on the slightly technical issue of what status you should place on a draft code, but I just thought, to the extent relevant, that's the contextual position. And the draft code reorders the capacity test in line with JB. And right at the end of my submissions, I will get back to the question that Lord Justice Singh asked, why does it matter? Because in my submission it does matter, and I'll explain why in a little bit, if I may. So turning first to belief, the point that the reason Mind wanted to intervene, or one of the main reasons Mind wanted to intervene, was a very simple one. It was to ensure that the court leaves room for patients to disagree with their doctors, service users to disagree with their social workers. That's what Mind is really we think it's extremely important that the court has everything before it with that, I don't want to say policy aim, but in effect, policy aim underneath. And it's particularly important, we say, in the context of those with mental health conditions, those from minoritized communities, and those with religious convictions. Because there's a real danger that if the court elevates belief into some kind of criterion within the Mental Capacity Act, that the Mental Capacity Act will inadvertently start to discriminate against such groups. Just to take an example, religion. In some examples, religious belief is just going to put an option beyond the pale. It is completely inconceivable that a Jehovah's Witness could accept blood. No desire to die, they just can't. Is that then going to mean a person is unable to make a decision about accepting blood? I won't take the court to it now, but there is if I may respectfully commend to the court's attention, Mr. Justice Mostyn talked about this in really characteristically trenchant terms in the Nottinghamshire Healthcare case, an RC case. It's Authorities Bundle, tab 26, page 467. And it features a kind of cameo from J.S. Mill. But that idea that in some circumstances a belief just means something is beyond the pale, and how can one think about that? It's also just not uncommon that people are going to disagree with honestly held professional opinions, even if that opinion is objectively verifiable. And the term objectively verifiable appears in the trust submissions. I think it's paragraph 3A of their skeleton. Because it simply wasn't the intention of Parliament to require people blindly to accept other people's predictions. That wasn't what the Mental Capacity Act was about. It wasn't to deem, and I'm not sure this is a term I'm allowed to use, but it wasn't to deem, for instance, anti-vaxxers to lack capacity simply because they don't accept the overwhelming mainstream medical evidence about the benefits of COVID vaccination. And we can go further back in history for that. I mean, the Law Commission, when it was starting its... When the Law Commission was beginning its work in the 1990s on thinking about capacity and recognising there was a problem, they made clear many beliefs or value systems have little or no rational basis, but we nonetheless respect people's rights to hold them, even to their own detriment. And for the court's reference, that's from the Law Commission's consultation paper in 1993. It's tab 79, page 1396, paragraph 2.15. But, and it is a really very important, but Mind entirely accepts there are going to be situations which do require further analysis. And it's that further analysis bit which understandably and clearly was troubled Mrs. Justice Roberts, and a strong sense one gets from watching the panel this morning, it is troubling this court. The starter for 10 in my submission is, it's common ground as far as I can see. There is no statutory belief requirement in the MCA. I mean, that's self-evident. The language is understand, retain, use and weigh. And we do reiterate the Supreme Court in JB, please could you not put glosses on the words of the Act. It's there, it effectively does what it says on the tin. And mine's real concern is that the Court of Appeal isn't led inadvertently to introduce a belief criterion by the back door. We were casting around to try and think of what other assistance could be provided to try and think about what is really a very difficult area. And if I may take you to Australia, there is a decision of Justice Bell, Kevin Bell, in the Victorian Tribunal, considering a piece of legislation which looks effectively identical to the MCA. And he grappled in a very clear and, in my submission, very thoughtful way with how do we think about the situation of belief. If I could ask the court, please, to turn up, it's the case of PBU, which is at tab 48. I'm sorry, this isn't an Ostley equivalent of Bailey transcript. I don't know if there is a better transcript available, but hopefully it will do. So as I say, the case is at tab 48. But in effect, it concerned two individuals and in relation to whether they should have ECT. And in the Australian context, that was a capacity-specific question. And so there's a very high stakes issue there. ECT is a treatment which could well provide a lot of assistance. It's also a treatment which is highly controversial. Many people feel very troubled about having ECT. So not as high stakes, perhaps, as this case, but still very high stakes. He has quite a long discussion about thinking about belief and insight and how to think it through. It's paragraphs 183 to 198. I would, if I may, invite the court to reflect on that whole section in due course, so 183 to 198. But I'm very grateful to my learned friend. 1096 is where it starts, if you wanted to make a note. But just for present purposes, I wonder if I could just ask you first to turn to page 1101 and paragraph 95. I mean, this is just to contextualize it. It's the paragraph, the way in which lack of belief or insight in respect of illness and the need for treatment is considered when assessing capacity is a matter of importance to people with a mental disability. It's because it's not uncommon for various personal, social and medical reasons for a person with mental disability to deny or diminish the illness and the need for treatment or to choose non-advised treatment. But equally, nor is it uncommon for various personal, social and medical reasons for persons not having mental disability to deny or diminish illness or the need for treatment or to choose non-advised treatment. In neither case does this mean, in and of itself, the person lacks capacity. He then goes on to talk about quite a famous Canadian case called Starson, about whether or not an individual there had capacity to make decisions about medical treatment for mental disorder, which I don't need to trouble you with now. But can I ask you to turn back, if I may, to page 1089. Oh, sorry, 1098. Incapability of reading my own writing there. So, and it is paragraph 189. You will see, if and when you come to look further at this case, that Justice Bell goes through basically all of the English case law. He is extremely interested in English case law. So he looks at the pre-MCA case law and he looks at post-MCA case law. So the court might find it of assistance to have, as it were, a critical judicial friend having looked through this, having grappled with almost exactly the issue that you are doing now, having to grapple with now.
Does he deal with Justice Mundy?
Yes, he does. Yes. I'm terribly sorry. Off the top of my head, I can't immediately. It's.
By which I mean.
Yes.
Justice Mundy and
yes. He does. I think it is. I'm sorry, Lord. I'm now just. If you just give me 1 second, I should be able to find it.
Footnote 239, paragraph 187.
Yes, but I think he then also talks about him. Yes. Yes, well, that I mean, local authority X is the MM case.
Sorry, which paragraph are you on
It's
there?
it's 253. It's footnote 253 on page 1100.
Yeah.
Thank you, my lord. But the point I just wanted to draw out for the court's attention was the observation in relation to receive. I mean, it's a pre-MCA case. You have our submissions in our written submissions about the extent to which pre-MCA cases are determinative. But for present purposes, working on the theory that the court might well think, well, we need all the learning we can get, in my submission, that what his analysis of receive is extremely helpful. Because what he's drawing out is the fact that one needs to be very cautious about saying it's not just that you have to be capable of understanding, but you've actually got to believe it. So there's the distinction between you're in principle capable of understanding, and actually what we're now requiring you to do is actually demonstrate you believe. And then he goes on to say, on one view, this means that a person who doesn't subjectively accept the diagnosis of illness or has no insight into it or the need for treatment lacks capacity in respect of the treatment decision. I mean, that may feel quite familiar in light of your reading of the judgment of Mrs. Justice Roberts. And then he goes on to say, this is to treat belief or insight.
Where paragraph are you in now?
189, my lord, at the bottom of page 1098.
Yes, thank you.
So, just to reiterate, on one view, this means that the person who doesn't subjectively accept the diagnosis lacks capacity. And then it's the critical bit I would emphasise for the court's attention. This is to treat belief or insight in respect of the diagnosis and treatment as a criterion of capacity, i.e. a normative consideration, and not just as a factual consideration. So in other words, it's elevating it into a thing thou shalt do, thou must believe, otherwise you lack capacity. Rather than simply it is something which is in the mix, that we're engaging with someone who doesn't appear to believe.
I'm not sure I would accept that proposition, because as Mr. Quintavalle has been at pains to emphasise today, capacity is not the same as, for example, impairment. So just because you meet one of the tests in here is the 2005 Act,
Yep.
it wouldn't necessarily follow that you lack capacity, because the trust says, well, there could be all sorts of other reasons, like your faith, for example, why you don't believe something.
Yes, my lord. So I don't disagree with you for 1 second. I suppose what I'm focusing on at the moment is the functional limb.
Yes.
Yeah, but there might be a second order issue, which is you don't seem to be able to use and weigh, but it's not for a reason we can house within the Mental Capacity Act, and then that raises another a different issue.
I understand the point you're making. I was simply suggesting that some caution needs to be exercised. Obviously, we find it very helpful to be shown an Australian decision, and I have great respect for Mr. Justice Bell. But I'm not sure I would necessarily use the words he's used there.
Very well, my lord. It's really the point I was hoping to extract from it, and I'd also commend that the wider analysis there is the caution that's required before elevating belief into a thing thou must have,
Yes.
as opposed to this is part of the mix.
Yes.
And so, aware or anticipating that one of the reasons that the court may have granted permission to appeal in this case was to try and, as it were, make sure that going forward people were clear about how they should handle what is really quite a difficult issue. What Mind would suggest, and we touched on, we addressed this in our written submissions at paragraph 11, but what we would suggest how to navigate between the two, or navigate accurately here, to work out is this a situation where the person genuinely cannot understand or use and weigh the relevant information, or it's the person having a disagreement. The critical point to focus in on is, can the person understand, and can they use and weigh the possibility that doctors might be right? And if they can do that... Sorry,
No, I didn't want to interrupt you.
Yes.
You finished. At some point, can you please assist me at least resonates with the question I asked Mr. Quintavalli,
Mm-hmm.
which is, may it be legally significant that it's not just understand, but also use and weigh? I can certainly see the point that you're making, that it's perfectly possible for a person to understand something even though they don't believe it.
Mm-hmm.
But I'm not so sure I understand the submission that you can use and weigh the information, because you would be giving it zero weight. If you don't accept it, you can't weigh it.
No, my lord, that's a very. I mean, one has to be able to do all the bits,
Yes.
as it were. And I would also, I would entirely accept your lordship's premise, which is effectively they're cumulative. If you can't understand something, you can't retain it. If you can't understand and retain it, you can't use and weigh it.
They're also separate.
Exactly, they're separate and have to be. And Parliament intended that they were all doing legal work.
Yeah.
And the judge in this case, in paragraph 93, which I mentioned earlier, Mr. Quintavalli didn't particularly want to focus on, but in paragraph 93, that is where the judge seems to, as my lord is focusing on, belief as being relevant to use or weigh, rather than understand.
Yes. What? To some extent, my lords and my lady, it doesn't really matter where it is housed. One could say it's housed under the understanding limb, or it's under the using and weighing limb. But if the point is, are you able to understand? And if you can understand, can you use and weigh the fact that the doctors might be right when they're telling you about the prognosis? And if you can do those, then the patient or the doctors are engaging with a capacitous patient who is disagreeing with them. And so, to summarise, and I will then have to be very speedy on diagnosis, to summarise, what mind is extremely keen, if at all possible, is that the court makes clear or does not elevate belief into, as it were, an additional limb. It's not needed for purposes of the Mental Capacity Act. And when you start elevating it, you start running into all sorts of unnecessary problems in relation to potential
But aren't we
discrimination.
going to have to tiptoe around Mr. Justice Mumby a bit? You haven't actually looked at what he actually said. Yes, Mr. Justice Bell cited the subsumed sentence, but he didn't cite the previous sentence in LLM, in which Mr. Justice Mumby said, if one does not believe a piece of information, then one does not in truth comprehend or understand it, nor can it be said that one is able to use or weigh it. So that is a much more definitive assertion, and it sounds to me as though mind doesn't want us to accept it.
Well, no, my lord, can I, do you mind purely for time reasons, so that if I make two very short submissions on that?
And then leave it to Ms. Gorbs.
Well, that was going to be my second submission, actually. In the sense, well, no, and that's not mean to unfairly leave it to her. It's that the OS has very developed submissions on this. The very short submission I'd make is, we are where we are with the Mental Capacity Act, which does not include a belief requirement. And so you are the appellate level court grappling with this for the first time. It is for you to decide, are we going to actually, in name or in substance, import one? And mind is particularly keen that you are very cautious before going down that route. And the way in which I framed it in terms of please probe whether the person can understand and use and weigh the fact the doctors might be right is the way in which you can get to the things we need to get to without having to get to using the word belief, which just carries with it a whole series of additional problems we basically don't need, is my submission on that, if I may. I may stray slightly over the 30 minutes if
Well, you don't need to smile at us. Smile at Mr.
yes,
Oliver.
I'll be as quick as I can.
He wants me to do all the work, but in a very friendly
I know.
I
As
know,
ever
it's-
thus, I'm afraid.
we may take this out. So, in terms of the not diagnostic element, it's simply the reason for not talking about diagnosis. It's not a medical matter, capacity. And if we keep saying diagnostic element, including me, we keep giving the message it's medical. It just isn't. So in my submission, it's much better to talk about the impairment condition. The second point, sorry, second of 4. Mr. Quintavalle, my learned friend Mr. Quintavalle is very much wanting to emphasise you only start considering a functional test if there's an impairment. With respect, that simply can't be correct. The code of practice, the current code of practice makes that clear. For your reference, tab 63, paragraph 4.36, page 1182, because it suggests one of the reasons you may be questioning someone's capacity is their behavioural circumstances causes doubt. And if you need further authority, or my proposition is, the need to consider capacity comes in when there's legitimate reason to doubt, or good reason for cause for concern, or legitimate reason for doubt. That's a term I've lifted from a case called Royal Bank of Scotland and AB. But in my submission, I'm not sure it's a proposition which needs authority, because it has to be the case that if there's a reason to consider, one has to consider. The third point is, Mind really wants to ensure that the court's very aware of how much the NCA, what you're looking at is such a... Yes. The GMC guidance, I managed to print off the wrong bit, I'm afraid, but I'll get the right bit sent over, says it's a core clinical thing and you need to be alert to signs your patient may lack capacity. It's applying the whole time. And the test is, do you reasonably believe, in the context of care and treatment, the person lacks capacity? Section 5 Mental Capacity Act. And put very starkly, and thinking about Article 2, if there really was a need for some kind of formal diagnosis of impairment, Christian Eriksen, the footballer, would be dead. He collapsed on the pitch in the Euros. The paramedics intervened on the basis of a reasonable belief he didn't have capacity to consent to CPR. That's one of the areas, most of the areas the NCA is designed to deal with.
Well, it was not, it's obviously a few years now since I did these cases at first instance, but it was not uncommon to have cases where you had a clinician expressing a view about capacity, a non-psychiatric clinician.
Yes.
And a psychiatrist called as an expert witness.
Mm-hmm.
As I recall, the courts weren't obliged to accept one or the other.
No. There is a distinction which I just think is maybe important. I think at a couple of occasions I could just see there might have been a very slight cross purposes. When we're thinking about deprivation of liberty matters, and the court is authorising, the court has to have before it medical evidence. Yep. But that's got nothing to do with capacity. That's because Article 5.1 yes. So I think, my Lord Justice Singh, I think that's one of we've got medical evidence dealing with mental disorder, or the horrible term unsoundness of mind, to deal with deprivation of liberty. More broadly, no need for medical evidence. And I don't think I need to labour that point anymore. And then the very last point was to answer the question you asked, Lord Justice Singh, which is, well, why does it matter what order we put this? The King's College case, actually, which my learned friend Mr. Quintavalle took you to, is really helpful on this. Partly because it includes a discussion of the PC and NC and City of York case, which is where ordering does matter. It did matter. Because if you start with impairment and tick it off, you run the risk of not thinking properly about why the person can't, for instance, understand the information. And then in the King's College case, the one at tab 24, that was there, Mr. Justice MacDonald says, I'm focusing on, can she understand, retain, use and weigh? I think she can. And it's paragraph 93, he's very clear that essentially he's extremely relieved the test is that way round, because it means he doesn't then need to go on and think about whether someone who's being diagnosed for the first time in hospital with emotionally unstable personality disorder could really, or should really, be found to lack capacity for purposes of Mental Capacity Act. So he'd done the exercise of thinking through and reached a conclusion. She's got the functional ability, therefore, as it were, I stop there. And the very last point I'd make there is, it also matters more broadly, because if one is loading people outside court, and your judgment will apply 99, I mean, the percentage, your judgment applying outside court, the ratio of your judgment applying outside court to your judgment applying inside court is enormous. And if one gives the message that you start with the impairment, you are loading people to approach individuals with mental health conditions by getting them to look at them as this is a person with a mental health condition first, which inadvertently nudges towards, I think they may not be able to make a decision. As opposed to if you focus on what they seem not to be able to do, you're focusing on when Parliament told us we need to focus, if that assists. I'm terribly sorry to my learned friend, Ms. Gollop, I've gone just about 5 minutes over. I should also apologise, my lady, my lords. I had a prior commitment, which means I'm simply not able to be here tomorrow. I intend no disrespect. If anything comes up, my learned friend, Mr. Allen, is more than capable of handling everything. So I hope if I may be excused at the end of today. Thank you very much.
Thank you very much indeed. Most helpful. Ms. Gollop.
Lady, you started by telling us, and we must apologise, and I will on behalf of all of us, that it's been unhelpful for you to have new documents at short notice. In paragraph 44 of the official solicitor's skeleton, I referred to the document that we filed in support of the parent's application for permission to appeal, statement of grounds, I think, which you don't have in the bundle. And I referred at paragraph 44 to paragraphs 12 to 14. I'm not going to trouble you with a new document, but I'm briefly going to tell you what we said there so that that makes sense if you reread the skeleton. And it explains perhaps why the official solicitor's given this as much attention as she has. She says that, and she has approved this, both documents personally, that she acts on behalf of many patients who have been hospital inpatients for a long time, who will often have been exposed to intensive medical interventions and have witnessed distressing events. Those people will often be vulnerable as a result of their condition and their need for treatment. Some of them may be towards the end of their life or suffering from terminal illness, and their autonomous decision-making power can be especially precious to patients in this situation. And I mention in particular one case that I'm aware of, and there may be other situations on the ground, where people want to make an advanced decision to refuse treatment in that situation. And we do need to be careful about preserving the space for those who have capacity to be able to do that. So as soon as one of the reasons why it's unfortunate that it was necessary to have to determine the capacity issue, but it was necessary, is that it took away that space for Sudiksha. The official solicitor goes on to say that not infrequently people in this situation defy medical opinion about their life expectancy and consider that their rejection of the advice they've been given about prognosis has been key to their survival. And she is concerned lest those who believe that doctors who tell them death is imminent are mistaken, are thereby held to lack capacity to decide whether to pursue further treatment, including treatment not recommended by those who are treating them, or whether to agree to receive palliative care. She is also, and I reiterate this, very grateful to the parents for bringing the appeal that they have. She herself did not appeal, but as you said at the beginning, this raises such important matters that would not have had the opportunity to be ventilated before this court if they had not done this. They will want to know that their daughter has made her mark on the world, which she certainly has, but your attention to the issues that she brings before the court through her parents is very important. And perhaps going back to Mr. Justice Bell's decision that we've just been looking at and his use of the word normative, what she also tells us through the evidence that she provided to the official solicitor and the solicitor whom she personally instructed about her wishes and feelings for herself, her attitude, her values and the belief at the end of her life, may tell us about possibly the position of others and stand as a corrective about any temptation to have a normative approach to patients in the awful situation in which she found herself. Later, I'm going to come straight on to belief, but I want, if I may, to just grapple with the issue about belief, not just in relation to the word understanding, but I think the words of Mr. Justice Mumby, as he then was, were that it's subsumed within what he calls the general requirements. And I wanted to take you briefly, just because you may not see it otherwise, and while it's on my mind and I don't forget, to one of the textbooks that the Trust takes you to, and to the words of Baroness Hale, as I think she then perhaps wasn't, but they will resonate now. So the textbook is Mental Health Law. The extract starts at electronic, or we've got electronic and paginated, same, 1354. Is it 74? Thank you very much. It's tab 74. Grateful. And then you're looking at page 1357. At the top of the page, you've got helpfully set out what are now, under the MCA, the general requirements. And then you've got a paragraph beginning, the test involves. 1357.
No, it's not that I haven't lost the page. I was trying to look at the date of the publication of this book.
2017, according to the index.
Right, thank you.
So this is the book, it's now in its 6th edition. It was originally written by Ms. Hale.
Very thin brown cover.
Earlier on in her career.
Right, so we're
It's
looking.
got the imprimatur of a high authority in its original edition, perhaps.
Even higher than the Blue Book. Yes.
So he starts by, or the book starts by telling us that the test involves the ability both to understand the information and to use that information to make a choice. It says, whether this is right or not, I don't know, it expands upon rather than contradicts the existing common law tests. But then I think goes on to tell us that the common law tests may have been wrong. I don't know. Then there is reference to the case of MB, and reference then to the fact that re-MB largely adopted re-C. And then there is the following sentence, which may assist. The judge in that case, I take that to be re-C, included an extra requirement that the patient believe the relevant information. But that cannot be necessary because the information given could be wrong. The important thing is that the patient is capable of weighing it up. If it's right that Mr. Justice Momby was looking at all of the general requirements, but here this textbook is focusing on the extra requirement of belief. This book is not necessarily attaching that to any one of the general requirements set out at the top. It's not saying, and perhaps we've gone down a rabbit hole that we didn't need to go, or a cul-de-sac perhaps, by focusing too much on does the word understand connote or have subsumed within it belief, when we should have been looking at all of the words. But the point that's being made here, I think, is that it can't be right that there is a belief requirement in relation to any of the requirements on the functional test, because the information given could be wrong. What's important is that you're able to understand it and you're able to use and weigh it. You can do all of those things without having to believe it.
And she goes on, and of course, he may not be able to do that if his impairment or disturbance prevents him from believing it. And cites an Admin court case.
Yes. But it's still coming back to inability to understand, use and weigh, not inability to believe. So the person, the capacitous person, who is making a decision in the absence of an impairment or disturbance, might understand and use and weigh information that they don't believe and be able to do so capacitously. So might a person who has an impairment, but it's not an impairment that's causally related to this decision. The simple point is, the word is absent for a reason. The only requirements, the only functionally, are the ability to understand, use, weigh, retain and communicate.
Does it follow from that you accept the proposition that the fact that somebody does not believe some information may mean they lack the capacity to weigh it?
Yes. But it's a may, not a must. That must be right. Yes, definitely. I mean, there will be circumstances in which somebody knows a lot of those that one's looking for.
Lady Hale's book is giving the scenario where the information given could be wrong.
Yes.
But if we turn that around to a different scenario, where the information given, let us assume, is not only correct, but it's incontrovertible.
Yes.
Now, I may be wrong, in which case Mr. Sachdeva will correct me in due course. But I think the trust submission is that if you're in that scenario, then you can't understand something if you don't believe it.
Yes, and I think I understand, and I
No. I should. Before you continue, forgive me. Speaking for myself only, I'm not at all convinced that that's right. Because,
I understand it's not your point.
Yeah. Because I speaking for myself only, I do think that in this appeal, this court is going to have to grapple with whether Mr. Justice Mumby was correct or wrong, and sometimes Homer has nodded.
Was it Overton, what he said, by the way, in that man? Another pebble out.
We were just, when Mr. Quintavali mentioned about not believing whether somebody stabbed you or not, I did say to Mr. Rutkeen, where's that coming from? And we did have a look in MM and note the paragraph where he, in that case, said he hasn't stabbed me when I think he patently had. So I will go back and look at that. It may, if it is obiter, then we've all been relying, and Mr. Sachdeva in his one of his position statements called it trite law that you have to believe. So we've been, if it is obiter, we've been elevating something that was obiter to something that's now become trite. But you've seen the way I put the submissions, that people now sort of take this almost as though it's been handed down in tablets of stone, very unhelpfully.
Do you, picking up what Mr. Rutkeen said, do you accept his coda, gloss, I'm not sure quite how he'd describe it, that the critical point is, can the person understand and can they use and weigh up that the doctors might be right? Do they need to, before they can be deemed to have understood and weighed it, do they have to be able to accept the doctors might be right? They just don't believe it? A concrete belief? Why do they have to? Why do they have to believe the doctor? Why is it necessary for them to believe the doctors might be right, or acknowledge the doctors might be right before they pass the functional test?
I would step away from any gloss over the statutory language. I don't know whether that was a slip of the tongue. I don't know. The only requirements of the Act are understand, use and weigh and retain. It will depend on a situational case-by-case basis, I think, as to the reasons, perhaps, why somebody doesn't give weight to a matter that they understand, or chooses not to use as part of their processing a matter that they understand. But what you need to be understanding, using and weighing is the relevant information. I think once one starts talking about belief in what the doctors are saying, you might say, I really just don't like him. That doctor really gets on my nerves. But the focus of the act is on the information, not the source of the information. So long as you're understanding, using and weighing, I just think any suggestion of a belief requirement to any part of the functional test, let alone all components, or one or any combination, takes us into dangerous territory, not least because of the unhelpful religious belief, secular belief, or rational belief, and so on.
Well, maybe belief is the word that's been used throughout. Maybe it's the wrong word. Maybe what we're talking about is accepting the possibility of the truth of.
The word in Re-C, I think, is comprehend, which is closer to, in my mini thesaurus, to understand. I think in some of, Mr. Rutkin will know better than I have, and maybe I've got this from the Australian case, that some comparative jurisdiction, there's discussion of an appreciation of information.
I don't think with respect, I don't think we can duck the issue.
No.
Paragraph 93 of Mrs. Justice Roberts' judgment in the present case, I read to be a self-direction in law that belief is an essential requirement of this statutory formulation. Mm-hmm. Now, she's either right or she's wrong about that, and I think we've got to say so as a matter of law.
Yes.
She's interpreted Mr. Justice Mumby in one particular way, and I think it's the first sentence of the two, rather than the subsumed sentence, which she's right. I mean, there's no clear, isn't it, what she says?
It's clear what she says, and I wasn't there on that occasion. I was there at other hearings, but I wasn't here at the August hearing. But I suspect that she was being encouraged to rely on that, because I imagine it was his persuasive submissions in combination with many other cases. And you've seen the case of MPZ that I think that we've both looked at, where the judge there said that to understand is to believe.
That's in MPZ.
Yes. Yes.
You're just lining up a list of cases for us to say are wrong. Is that what you're saying?
Well, they all flow from. They all flow. It's MPZ, which is tab 13. I'm very grateful. I've discussed this at some length. The paragraphs 10 to 16 of the official solicitor's skeleton.
This is your archaeology.
It's my archaeology, page 282 to 284. So what the Deputy High Court judge ended up saying in that case was, the case law makes it clear that a failure to believe is a failure to understand and use or weigh. And another more recent case. I said that it's almost as though what Mr. Justice Mumby had to say has sort of been elevated to something incontrovertible. And it does seem that many judges are relying on that as a statement of the law which is correct, and there is an additional requirement built in to the words of the Act. But I wanted to come back to what my Lord was asking about, is there a belief requirement in information that is incontrovertibly factually accurate, if we put it that way, rather than true?
Yes.
One could say that in this case that was the issue here, because the medical evidence was all one way. Now, one could say, well, it's not incontrovertibly reliable evidence because it is a doctor's prognostication of the future, and therefore you could file it under the classification of opinion evidence, which I think is one of the points that Mellon from Mr. Quintavalli was getting at.
Forgive me for interrupting you. The difficulty with that response may be that, as we've seen from Lady Hale's textbook, Section 3(4) of the Act provides expressly that it includes information about the reasonably foreseeable consequences.
Yes.
And that formula, to my mind, is interesting because it doesn't even say it doesn't say consequences. It doesn't say foreseeable consequences. It says reasonably foreseeable consequences. So it might be said that that imports some objective element, and this is part of the information that you have to have the ability to understand, use, and weigh. So if the doctor's prognosis is, we're telling you that the consequences of your actions are going to be X
Yes.
rather than Y.
Well, any consequences must axiomatically belong in the future.
Right.
So we are talking about something that's not objective in the sense of is it a lemon or is it an orange, that sort of fact, which we can look at, draw on our senses, material reality in the present. Neither are we looking at a past which might have different analysis. We're looking at the future. Even then, I would say that there is space for somebody to disagree with what is otherwise classified as incontrovertible. Because Sidiksha would say, you say to me that the reasonably foreseeable consequences are that I will die perhaps in pain, perhaps without my family being there, perhaps in a chaotic, unplanned situation, because I'm going to die, and unless I accept your palliative care plan, which can be choreographed and managed and planned, and my death can be made to happen at a time when I have everybody around me pain-free and so on and so forth, then those are the reasonably foreseeable consequences. But I am telling you that it is reasonably foreseeable that you are wrong, because you have been wrong in the past. So there might be lots of sets of reasonably foreseeable circumstances.
Yeah.
So that's a problem.
Yeah.
And
Yeah.
I can see that feels as though it's avoiding a situation where there's only one. But I think in a medical treatment case, those situations might be rare because you are looking at the patient's individual lived experience. And I've dealt with this, talked about what might be her truth.
Yes.
Yes.
Well, that's a fundamental
Yeah.
point, it seems to me, that when we're talking about what someone believes in these circumstances, we really are at the heart of personal autonomy in this context. And to take away, that's the motive for it, to say that someone lacks capacity because of their beliefs in these contexts is a significant infringement of personal autonomy. The way that you agree, the proposition I put to you, I don't know what the precise wording, that you agree that with the proposition that the ability to use and weigh information may be may not be present if there's a belief. You accept that it's not must.
Yes.
I put it better. You agree with that?
Yes.
Depends on all the facts and circumstances.
Yes, and I wonder if I might take you to another of the textbooks helpfully cited by the Trust, and I think it's the same paragraph that they look at, which may assist in this regard, which is the McHale textbook, which I think is 75, I think. And this starts at 1359.
Is this the latest incarnation of a textbook that I know as Kennedy and Grubb? It was the first edition. I see they're consultant editors.
I think it is, yes.
Yeah, that's the one I remember using. Thank you.
And I think, in fact, there might be a new edition
No.
that within days, possibly, of today. I could be wrong. We will.
So just
Yes.
sorry to interrupt my learner from Mr. Allen's one of the authors, so months.
Well, he'd know then.
Yes.
Lang, McHale and Allen.
And it's at 1362 at paragraph
9.88 is sideline.
9.88. But also at the The same use and waypoint comes up in 9.87 in connection with discussion of the case there of a patient who had renal carcinoma and as a result of mental health problems didn't consider that she was ill and didn't want treatment, and delusions meant that she regarded medical treatment as unnecessary and believed that the medical interventions recommended were part of a plot against her, and said that the patient lacked capacity because unable to use or weigh information. Sorry.
So should we just read through 9.88 ourselves?
I'm going to warn you that I will ask you to read all of this. This is the only authority thing I want you to read every page of. There's quite a lot in it that's highly relevant.
Thank you. We're just reading 9.88 at the moment, Ms. Connor. I think we'll read the rest in
Yes.
due course. Thank you.
I've taken you to that because that sentence about 4 or 5 lines up from the bottom, merely to take a different view of the world from a doctor, may result in a patient disbelieving him, but it does not render the patient incapacitated and thus unable to decide as a matter of law for themselves. So I take the may there means that it may render you incapacitated, or it may not.
Is that the same receipt? It is the same receipt in Mr. Justice Thorpe, as is cited by Mr. Justice Mundy.
No, this is a much later receipt, I think. It looks as though it's 2016, and therefore it's well post MCA. Whereas
No, I think it's the same one. It's 1994. Yeah.
Got the All England citation as opposed to.
Footnote 139.
Must be the same, must be.
Yeah, it's the same one.
yes, sorry, I'm looking at receipt underneath.
Yeah.
Yes, the first one. Yes. And to go back to my Lord's question about belief, it's also here, and again, this is another problem with the use of the word belief. We're looking at different kinds of belief. So we're talking about outright disbelief, rather than a more thoughtful, comprehending, appreciative, comparative exercise of self-assessment and the medical advice, I suppose one would say, about the reasonably foreseeable consequences. Could I take you to another difficulty that the official solicitor foresees with any sort of a belief requirement in any of the general functional tests? And I think one of the points that we've made in the skeleton, I'll find the paragraph in a moment, is that it requires, it's paragraph 33 on page 288. It requires quite a sophisticated gloss on the words of the statute in different circumstances, depending on how one categorises the relevant information. Going back to my Lord's point, if we try to think about incontrovertible, all one way, evidence or information about the reasonably foreseeable consequences that we might somehow be able to classify as a fact, even though it's about the future. Well, you've said there it would be absurd if you have to read the Act as containing a belief requirement when the information is factual, but not a belief requirement when it's opinion. Either whether it's the opinion is all one way or the opinion is conflicting. If it's conflicting opinion, then how can you believe information that you're going to effectively maybe have a life expectancy of 6 months and another opinion that it might be 6 years? You can't believe both of them at the same time because one of them might be wrong, as the textbook tells us. For example, when the statutory language doesn't change. And I wonder if we see that difficulty in action in the trust skeleton, paragraph 30, page 263. So the summary of where the trust is on belief is where there's a medical consensus and the consequences of having or not having the treatment, as medical consensus as to those consequences. This is information which a person must understand in the sense of believing or accepting that it's true. So that we need a belief requirement in that scenario. Then B, if there's a range of credible views as to the consequences of having or not having a treatment, then you need to understand that there are different views as to the consequences of having and not having the treatment, and use and weigh up the information. Now, I take that as meaning that in that scenario, there is no belief requirement because there are conflicting views and a range of credible views. And then in C, the trust is suggesting that if there's a dispute as to whether the information is objectively true, that's a question for the court, which leaves us on the ground with a difficult sort of situation where you might need to have a specific hearing to get a judicial ruling on whether the information is objectively true. Then you go away, whether on the same day to a conference room, I don't know, returning after lunch for a capacity assessment to be performed on P with the objectively true information to see whether they believe it and therefore meet the statutory test or don't. And all of this when the statutory language doesn't change. So there's practical difficulties. We don't think it's necessary. I think the words of the President in relation to glosses, we need to look carefully as to whether it's actually necessary to refine, if that's the better word than gloss, the statutory language. It isn't necessary. It creates difficulties where there were none. And it removes space for personal lived experience to be weighed in the balance and given weight to, for example, or a person's own values and beliefs that they bring and weigh up alongside medical evidence of no doubt highly qualified professionals who have great experience, but the patient has to make the decision for themselves based on what they know of themselves.
Can I ask you what the official solicitor's position is on this? And I will certainly be asking for assistance from the trust on this as well. Is a person entitled to... do you accept what Lord Donaldson said in RET? That even if something is completely unreasonable, that an adult person in this jurisdiction has the right, the personal autonomy to be treated as they wish to be treated. And it's only if they lack capacity that you could then start overriding. So in other words, it's not just that they might have a different set of values, they might have... Do you go so far as to say that even if their belief is completely unreasonable, the law still protects their right to act as they wish to be treated.
I think that probably comes down to a sense between the presence or absence of what we're not, the impairment, not calling the diagnostic part.
Well, you only get it. Well, first of all, you have the presumption of capacity.
Yes.
Right. So, I mean, if it's me, what on earth is the court up to? The court isn't there to decide what things are objectively true. If I don't believe them, even if my belief is unreasonable, then I think, but correct me if I'm wrong, I think the official solicitor would say the starting point is that the court has no business overriding that person's wishes, even if their belief is unreasonable. But, of course, then there can be legal incursions into that fundamental principle, because the presumption that somebody has capacity can be rebutted.
Yes.
One understands that, and then one goes through all the Section 2 tests in the MCA. I understand all of that, but I just want to be clear that the starting point is that someone actually is entitled to behave unreasonably.
Yes. And medical treatment, even if it's life-saving, cannot be provided to somebody who declines to have it without more.
Can I just follow that on to where that then, so you're that unreasonable person, not anyone that we're concerned in this actual case, but the notional unreasonable person says, no, I want this treatment. Now, where do we go with that? Because that may say, fine, that's a capacitor's decision, because there's no impairment, there we are. But then how does that merge and meld into the fact that a clinician, a doctor, cannot be obliged to provide treatment which they do not think is appropriate or clinically required?
Well, one might say, if that's the position, that somebody is saying, I would like this treatment, please, and the doctors are saying, I'm not going to provide it to you, I don't think it's an appropriate treatment for you, one doesn't get to court because there's no decision for the court to make. Nobody, capacitors, incapacitors, rational, irrational, can insist on treatment that a doctor's not prepared to provide. And a doctor doesn't
But
arguably...
they do come to court. They do come to court. So if we think in this particular case, the continuing dialysis was a big issue for the family and for the medical treating staff. And it was the clinical evidence that cessation of dialysis would lead to death pretty quickly, in a matter of days, probably. Now, if the patient was capacitors and said, I don't agree to a palliative plan, regardless of what you're telling me, foreseeable circumstances and all the things we've discussed, where does that then leave the hospital who say, but dialysis is no longer clinically appropriate and we're going to, notwithstanding that, cease providing it? Because normally what happens in those cases is they come to court and ask for a declaration.
Yes. And then they have to run the risk of, if that's the right word, the consequences of not getting the declaration. And I think it has to be right that in every time doctors approach the court for a decision, they must be prepared for the judge to say, I will not give you your declaration, in which case it is always understood that the doctors will continue to provide the continuation of the treatment that is currently being provided. That's slightly dodging the question. It leaves the doctors in moral distress and in a very difficult situation.
So what are you? So is what you're saying, and I'm sure we'll be helped by this by the trust as well, that in reality, when a trust comes to the court, they effectively are handing over their own decision making, and they will always honour the decision of the court. And if the decision of the court is treatment should continue, the best interest decision is treatment will continue, they will continue with that treatment, notwithstanding that their application had been that it's not clinically appropriate anymore.
Milady, yes, that is what happens, and I have to say, and others may have a different experience which they can tell you about, but I have not had the experience of a judge saying, I will not grant any relief on this application and you will have to go away and sort it out. I'm not going to give you the declaration that you seek, but neither am I going to say, for example, the trust, as perhaps here, were seeking a declaration that it's in the patient's best interest not to continue to be provided with the treatment. The judge would not say, I will not grant that declaration, and also I will not make a declaration that it is in the patient's best interest to continue to be provided with the treatment. That declaration gives the trust a lawful basis on which to continue to provide treatment that they had felt in their professional view was not in best interests. And doctors do that because they recognise that best interests is a concept that is wider than medical.
Yep.
Which perhaps tells us something about relevant information and so on. So one's not left in that sort of jeopardy. But there are cases where, and they sometimes even withholding of life-sustaining treatment cases, where a trust will say, we are not going to make a certain life-sustaining treatment an available option, and your challenge, if you want to bring one, is in the administrative court rather than the court of protection.
Well, thank you very much. I'm sorry I've taken you off the course,
not
but it's something that's been sort of just in the back of my mind about how we tied it all in together, because you can't, it doesn't stop at the court door.
Can I go back to what my lord was asking about RET? I would agree with everything that you'd said, but there are a couple of matters that flow from that. One is the uncomfortable feeling, perhaps sitting at the back of this, that given that we have a statutory presumption, Sue Diction might not have faced any challenge to her capacity if she'd simply said nothing. Not given any explanation for why she was declining palliative care, and simply said, thank you for your advice, thank you for your recommendation that my care is redirected down this pathway, I would not like to choose that, thank you. And then not engaged with any capacity assessments, not given any reasons, would have been left with the presumption of capacity, with somebody who has no mental health diagnosis, somebody there's passed GCSEs at school, as I understand it, and had you not contracted COVID, would have been at school studying for A-levels. There would have been no basis to say, we think you might be irrational, we think you might be delusional, at all. So one doesn't have to perform capacity because the Act gives you that presumption. Neither does one have to perform any aspect of the functional test.
Now, is that a convenient place?
Yes.
Very well. Well, we'll say goodbye to Mr. Rutkeen. Thank you very much for your submissions, and we'll look forward to Mr. Allen taking over from you in the morning. Mr. Allen, do sit on the front row tomorrow so that if we need you, hear you adequately. I think we're well on course, I think, from a time point of view.
It partly depends on how, call me paranoid, but I just wonder how much longer this rollout's going to be. I am enjoying the submissions, I should add.
Good. Fair we.
I'm just wondering how much longer.
Well, perhaps you can have a discussion, because obviously it's important, and of course Mr. Quintavani must have time to reply. So just bearing in mind that we have read everything.
Milady, yes, I think the only other issue for me to address you upon really is the question of potentially evidential sufficiency and perhaps impairment, which are comprehensively addressed. So I'll try to refine it and be succinct.
But we'll reread your Scandal overnight as well. But you must deal with all the issues that you wish to deal with before we hand over to the trust. Very well. Thank you all very much indeed.
Good job.